Hello and welcome to See You in Court, a podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. During each episode, we dive deep into stories, cases, and insights that matter to Georgians. You can learn more on our website at www.seeyouincourtpodcast.org. Join the conversation on our YouTube channel at See You in Court Podcast, and stay connected with us on our Facebook page at facebook.com/seeyouincourtpodcast. This podcast is sponsored by the Georgia Civil Justice Foundation. Your hosts are robinfrazerclark and lestertate, who are both past presidents of the State Bar of Georgia and who both serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Fraser Clark, and with us here today is our outstanding, fabulous co-host, Lester Tate. Hey, Lester.
Hey, I'm looking around to see who this fabulous guy is you're talking about. It's good to be with you. And although you and I do this by Zoom all the time, I'm right next door in your conference room today. Even though we're on separate computers, it's like a solar eclipse or something. You know, the planets have aligned.
Really, I'm glad you were able to come down and do this in our office. It's awesome. Glad to have you. Well, today we're going to be talking with Georgia attorney David Metzger. I'm looking forward to this, and it's about the new Georgia Squatter Reform Act. Let me introduce our listeners to David Metzger. David is a real estate attorney and litigator whose practice concentrates on nearly all aspects of real estate law. As a partner at Williams Tusink, David has experience in a variety of areas within real estate law, including landlord-tenant disputes, title issues, easement and boundary disputes, land use and zoning matters, property tax valuation and appeals, and more. David received a bachelor's degree in business management from the University of Georgia. Prior to attending law school, David served as a legislative aide in the Virginia House of Delegates. He later received his JD with honors from Georgia State University and was admitted to the Georgia Bar in 2011. Since then, he has represented clients in state and federal courts, as well as before municipal boards and local governments. He has been featured on several television news programs discussing real estate issues impacting the Atlanta area, and he has been recognized as a rising star by Super Lawyers and Atlanta Magazine. David has really stood out as an expert on real estate issues, particularly on housing and landlord-tenant matters, and he is here today to talk with us about the current state of homeowner rights in Georgia as they relate to squatters. David, welcome to the show.
Thank you, Robin. Very glad to be here.
Great to have you.
Glad to have you. Absolutely. David, if you will, tell our listeners a little bit. I mentioned your in your bio a little bit about this, but tell us a little bit about your career path. You didn't go, as the young folks say now, as my daughter says, from K to JD. And I had to try to remember what that meant, but it means from kindergarten to JD, which is what I did. But tell us a little bit about your career path and what brought you into the law.
Well, I appreciate that. I had to think about what K to JD meant as well. That was not what I did. When I graduated from the University of Georgia, I needed a little bit of a break from school, and I wound up living and working in a ski town in Colorado for a couple of years, got that out of my system, and got married. And my wife, we moved to Richmond, Virginia right after we got married so she could continue her training as a pharmacist. And it was there that I started working for a gentleman by the name of Clay Athey. He was a delegate in the Virginia House of Delegates, like a state representative here in Georgia. And so I was working for Mr. Athey as a legislative aide in his role as a delegate in the House of Delegates. And he was also a lawyer. And in fact, he was a real estate lawyer. He was a very distinguished land use attorney in Virginia. He is currently on the Virginia Court of Appeals. And so working with him, I, had thought about going to law school. I had actually worked in the mailroom at Seyfarth Shaw for a year before I got married, just to try to get a little exposure. And so it was kind of on my mind, but I set it aside a little bit. But then working with Mr. Athey, I saw kind of for the first time how other legislators would come to him with ideas for legislation or issues with legislation, and they would seek out his expertise as a lawyer to help craft legislation that would lead to laws that were effective and were enforceable. And so I kind of saw the connection for the first time between being a lawyer, knowledge of the law, those skills, and how that could help with policy. And that was very intriguing to me at the time. And so I admired that about him and what he did. And one day he said, you really should go to law school. And so I took the LSAT and came back down to Georgia, went to Georgia State, and became a lawyer.
I did a similar sort of thing. I worked for the legislature, and then I spent a couple of years on Capitol Hill in D.C. And it really does. I think it gives you a lot more tools for lawyering to have had that experience a little bit. Did you work on any land use type things? I mean, it sounds like he would be the guy you would go to if you had a bill you wanted to get sponsored that related to land use. So did you work on that particular area when you were working with him?
We did. There were a few land use issues that came up. There was a pretty large transportation bill that went through when I was working for him, and that had a lot of land use components and real estate components. But even more than that, it was, anything. I mean, people would come to him with all kinds of bills just because they knew that he, could help with the language and help with translating an idea into statutory language. And, ultimately that's how, policy and ideas get implemented out there. So it's got to be done right.
Even though folks might not want to admit this, but what we have seen at the Georgia Capitol is that lawyers, no matter which side you're on, Republican or Democrat, but lawyers get a boost up at the Capitol because everybody understands they know the law, they know how to write a bill, they know how a statute reads and the implications. And so being a lawyer.
The worst thing, though, Robin, is over the years, I've seen some bad lawyers get elected, and then everybody thinks they know what they're talking about, and they really don't know what they're talking about. So
we're not going to name those.
No, I'm not going to name any names. And most of those are tales from the past too. I think pretty good set down there right now.
Yeah. So was Judge Athey? I guess it's Judge Athey now. Was he your I understand your mentor, but was he the reason you went into real estate law?
No, that really was sort of happenstance almost. I mean, it's just kind of a coincidence that that's what he did.
Okay.
When I went to law school, I really didn't know what kind of law I wanted to practice. I really had no idea. And I, had taken a big gap. So I had friends that had gone to law school before me, and my now law partner, Eric Tusink, had gone to law school at Georgia State and graduated before me. And he and another friend of mine from high school who had also gone to Georgia State, his name's Todd Larson, they had both decided, they were going to start their own firm. And so I started working with them when I was still in high school. We rented what was essentially a closet in the SunTrust Bank building in the East Atlanta Village. And we wedged 3 desks in there, and we were kind of doing anything and everything just to keep things moving along. And then at a certain point, we started working with my now law partner, Kyle Williams. And Kyle was very well known as a real estate lawyer. He had been practicing for about 10 years at that point. and had a lot of experience, very distinguished as a land use attorney and a real estate litigator. And so when we started working with him, the overall practice naturally gravitated towards real estate law. And it turned out that was a very good fit for me and for the firm in general. And so here we are.
Well, I know Kyle very well, and he's just a great person. I know he's a great lawyer too, but he's a great person. So I'm sure it's wonderful practicing law with him. I love your story about wedging 3 desks into a room to practice law, because, Lester and I call that walk in the door law. There was a period of time that both of us did whatever walked in the door. We were taking it.
Some of us still are, Robin.
At that time, we were doing maybe Craigslist law, because we had a lot of advertisements on Craigslist, and one of my jobs was to man the phones and sort through all the stuff that we got. And there was a lot of crazy stories on Monday mornings and things of that nature.
Oh yeah, I bet there was some wild stuff on Craigslist.
So I've gotten drawn a little bit into some zoning issues and some condemnations and things like that. I mean, I'm more just sort of a general trial lawyer, but I always get somebody that knows the law in that area to help me and associate me with that. But can you tell me, it's a really wide range, when you narrow it, just to say land use, you can talk about condemnations, you can talk about zoning, you can talk about dispossessories, the squatters' rights or squatter cases. What type do you do more of, and what do you like about that?
Well, Lester, it's a hard question to answer because it changes somewhat. Sometimes I will break down what we do into stuff that's on the development side of things, which means anything that is helping with development or getting deals done. And so that could be permitting, it could be rezoning, it could be other things that you might consider traditional land use law. It may just be getting the city or the county to approve the permit or issue whatever certification you need in order to build what you want or get the deal done. And there's a lot of that work out there, and especially during times when the economy is up and the real estate market is up. There's a lot on the development side, and then you have contract negotiation and things of that nature. But then a big part of what we do is litigation. And so, really any kind of dispute that could make its way into court that involves real estate or buildings or anything of that nature, we're generally going to get involved in that. And so that could be something as complex as a very complicated title dispute to disputes over easements, boundary lines, contract disputes with tenants or vendors or builders. Again, if it's a dispute and it's involving some aspect of real estate, we'll get involved in it. And because our firm kind of covers both sides of things, the development side with land use and the litigation side with any kind of dispute, it's good. We cover our bases in that regard.
David, we want to talk to you a little bit about this fairly new law, Georgia Squatters Reform Act. But first of all, I want our listeners to hear a little bit about what a squatter is and I know I've seen the word intruder used instead of squatter, but I'll just be honest with you. I'm a personal injury trial lawyer, and the last time I studied property law was in 1985 in property. So I don't know anything about it. I see the news. Now, there's a lot going on that is in the news about squatters coming into someone's home, and it's just unfathomable to me. But can you tell us a little bit, first of all, what do we mean by squatters? Is that even a legal term? Or just fill us in on that.
Well, I would define a squatter as someone who has entered someone else's property without any authority or legal right, color of authority, anything of that nature that justifies their being there. And so they're essentially a trespasser.
Mm-hmm.
And, there are a few things that I would distinguish that from to kind of help paint a picture of who we're dealing with. Sometimes in the course of these conversations, people will talk about squatters' rights. And sometimes that goes back to property class in law school. And usually when you hear the term squatters' rights, it's associated with an adverse possession claim. Someone who has come into property and set up shop there, and they're doing it for a long period of time with the goal being that they can assert ownership of the property through adverse possession. That's not really what we're talking about with the squatters that gave rise to the Squatter Reform Act. The squatters that we're talking about, I've never encountered anyone that is claiming ownership of the property or is saying that they've been there long enough that they can be considered an owner, anything like that. They're really just trying to occupy a property and present themselves as a tenant, with the objective being to stay in the property without paying rent for some period of time. And so the squatters' rights term kind of gets thrown around sometimes, but usually that's not the situation we're dealing with when you're talking about adverse possession. The other thing to distinguish, obviously, is a tenant. And so a tenant is someone who has a property interest in property. It's a tenancy, and it's been granted by the owner of the property. And there's a true landlord-tenant relationship between the owner of the property and a tenant. And if you're going to remove a tenant from your property, you have to go through Georgia's landlord-tenant laws. There's a very well-defined process for that, an eviction process, dispossessory process, however you want to phrase it. But a landlord-tenant relationship is a prerequisite for going through the dispossessory or eviction process. A tenant, there's some authority. I mean, even if there's not a written lease or they've never paid rent, if you let them on the property and allow them, that is the legal authority that they need to be on the property and be considered a tenant. That's very different from a squatter. A squatter comes onto the property without any authority, without any permission or anything like that. And so they are different. And that's really kind of what we've seen in the last few years is people, breaking into properties and pretending to be tenants and then trying to stay in those properties for as long as they can without paying rent or anything like that before they ultimately have to leave.
So if, one of the things that I've noticed particularly in politicians and legislative bodies, and you may have too, is they frequently have more solutions than we've got problems. They come up with a new law when we really don't need one. What's the environment that sort of created the impetus for this Squatter Reform Act? I mean, how big a problem is this?
Well, things have improved. This law was signed by Governor Kemp in, I believe, April of 2024, and things have improved since then. But when you look at the situation in 2023 and early 2024, there was a huge increase in squatter activity in the metro Atlanta area. And there were a lot of property owners, homeowners, real estate agents, property managers who were extraordinarily frustrated at their inability to remove these criminals from their properties because they were being turned down by the traditional authorities. The police were saying we can't help you. The courts were saying that we can't help you. And so there was a lot of frustration, a lot of angst, and ultimately, I think that's what led to the pressure on the legislature to do something. And that's what led to the Georgia Squatter Reform Act. And, frankly, it was something that kind of came out of nowhere. I did in 2016, I was contacted by a real estate agent, and they had a client who lived overseas and had 2 properties in DeKalb County that had been unoccupied for a long period of time. And the real estate agent had discovered that there were 2 squatters living in each of those properties. And so we looked into the process, and that real estate agent was very astute in saying up front, I know these are squatters. There's no lease. There's no nothing. I can't just evict them through the normal process. I don't know what to do. And so we looked into the law for removing squatters, and Georgia has a law on the books, OCGA 44-11-30, which deals with, they use the word, Robin, as you said, intruders. Mm-hmm. It's a very old law. It dates back to before the Civil War, and it provided a procedure for utilizing the sheriff's office in that county to remove intruders from properties who were wrongfully occupying those properties. So we looked into that process and worked with the DeKalb County Sheriff's Office to initiate that process, and it was complicated. They'd never really heard of it before, never dealt with it. We had to work with some county attorneys to make sure that they were comfortable with what was happening. And, that was the first time that personally I had used the squatter removal process to remove squatters. I didn't have that come up again until 2021. And I had a few in 2022. And then all of a sudden in 2023, we were getting them by the dozens. I'd never seen anything like it. And so, it was a problem that kind of had never really been much of an issue. And then all of a sudden it exploded. And that's really kind of what gave rise to the pressure to have some legislative action.
Do you know what happened? Was there an event or what triggered all of this happening all of a sudden?
Well, that's a great question, Robin. And the best answer I can give is that it's a multi-factor issue. I think there were a lot of things that came together that gave rise to this. I think the biggest, in my opinion, is that coming out of COVID, there was a tremendous backlog of dispossessories in the magistrate courts in metro Atlanta counties. We had a eviction moratorium, and, even coming out of that, that ended in October of 2021. Coming out of that, a lot of the magistrate courts were just, struggling with virtual hearings and this huge backlog of cases. And so I think that prior to that, you didn't see a lot of squatter issues, because if anybody did squat in a property, it was probably handled through a regular dispossessory eviction, just like you would a tenant. Even though it's not technically, what you should do under the law, I think a lot of them, that's just the way it was handled. And so, that changed coming out of COVID, where before you could do an eviction action and maybe it would take 60 or 90 days from start to finish. All of a sudden with the backlog, it was taking 9 months, 10 months, maybe more. And so you had a lot of tenants who were, coming out of whatever their housing situation was during COVID, looking around, and, housing costs had gone up dramatically. And a lot of them said, well, look, I'm just going to let this dispossessory process play out, and I'm going to sit here and not pay rent for 9 or 10 months, save $10,000, and then I'm going to leave right before the marshals come to physically evict me. And so, that's a strategy that a lot was happening quite a bit. And then at some point, people figured out you don't really even have to be a tenant to play that strategy. You can just pretend to be a tenant. And so that's what the squatters started doing. And what they would do is they would make a fake lease, not hard to do. You download something off the internet. And they would show that to the police. When the police would get called, police would come out, and the squatters would show the fake lease to the police. And the police are trained that when they see a lease, they consider it a civil matter and say, this is not something we can handle. If you're a landlord and your tenant is not paying rent, you can't call the police and say, kick this person out of my property. That's not lawful. You have to go through the process. And so the police have rightfully been very well trained that, when we see a lease, we're, hands are tied. And so, that's what was happening. So, there's a lot of factors. Technology during COVID, a lot of things were put in place so that, you could get access to view rental properties remotely without in-person contact.
Yeah, I mean, that was one thing I was wondering is how do these squatters or intruders, or really, in my opinion, trespassers, even, let's say they're not a prior tenant, not a holdover, but you've got these people, how do they know what house is empty and I can forcibly enter that house and act like I live here? That's mind-boggling to me. But how do squatters know where to go? Like, oh, there's a house, I'll take it.
Very good question, Robin. Obviously there's a variety of ways that happens, but I think by far the most common is that the property is listed on the internet for lease or for sale. And there are pictures associated with that, and the pictures show that the property is vacant. And so a squatter can look at that and say, here's a property where no one's inside. So if I break into it, there's not going to be anybody there to call the police or dispute it. And so that is by far and away the most common fact pattern that we see is people will list it. And look, these days you have to put it online. You can't post it in the newspaper or anything like that. So, right. There's no alternative, but that's what happens. People put it online, it gets listed. I've had a number of cases. I had one where literally the day it was listed, a squatter moved in.
Oh my gosh, that's unbelievable. So before the new law, and let me ask you this, first of all, about the new law that was passed in 2024. So I don't think it's been in effect for a full year yet, but did you help work on the passage of that bill? Did you help in that?
I wouldn't say that I helped directly. I paid attention. I did talk to a number of the legislators that were involved, some of the legislators that were in the committees. And, a lot of them had questions similar to what we've discussed today. What is the squat? Sure. What is the situation out there? And so, we talked to them a lot about what our experience was, what the existing law was, and, discuss some of the ideas that had been put out there for trying to amend the law. So we were involved.
Absolutely. And before, when we had the old Civil War era law, what you talked about, people just went through the dispossessory process, which really didn't apply to the situation. Tell us about the new law and how it changed things for you.
Well, the law that had been on the books was pretty simple. And basically what it involved was the owner of a property would execute an affidavit stating that they owned the property and that someone was occupying the property as an intruder without, their authority. And that affidavit would then be given to the sheriff of the county where the property was located. The sheriff would take that affidavit and exhibit it to the occupant. At that point, the occupant would have the opportunity to provide a counter affidavit setting forth their good faith claim to be in the property. They could present that to the sheriff. If they did not have a counter affidavit, which most people don't have those laying around, then the sheriff would immediately, right then and there, remove the squatter from the property. Now, fairly basic, fairly simple process. If the occupant did produce a counter affidavit, then the matter would go to Superior Court for a jury trial.
Wow.
And so, you can tell from the law that it's very, very old. It's a time when the sheriffs had a great deal more autonomy. There's not the due process provisions and appeal rights and things that you would find in modern, kind of procedures. But,
right.
To be frank, it worked fairly well. It worked fairly well. The problem is that at the end of 2023, the sheriff's offices were overwhelmed. And so I was doing squatter removals through that process in 2023. And, maybe it was taking a few weeks. I did one in November of 2023, and I think it took about 3 months before the squatter was removed with the sheriff's office. But by the end of 2023, all of a sudden the sheriff's offices were just inundated with these, and there was a huge backlog. And so by the spring of 2024, it was taking 6 or 7 months, maybe longer, to get until the sheriffs would go out to the property for the removal of the squatter. And so, that's where you really kind of just see the outcry, is where people were, waiting and waiting and waiting, and nothing was happening. And there was a lot of frustration, Robin, because, if you're just a homeowner and you're renting out this property, and, somebody breaks in and they're living there without your permission and without paying rent, you call the police. They tell you that, we can't help you. You need to go to court. You file in magistrate court. For a while, I thought this was theoretical, but in 2023, we started seeing dispossessory cases in Fulton County against squatters get dismissed by the judge because they said, look, we don't have jurisdiction here. This is not something we can help you with. And so there were people that, were waiting 6 months in magistrate court for something to happen, and then just having their case get dismissed. So at that point, they're like, I went to the police, I went to the courts. What is left? I have no other options. And meanwhile, I'm paying a mortgage on this property.
I would think that might make some homeowners who want to rent their home or sell it resort to physical force. Like, I'll go in my own home and get rid of that guy.
Well, you did start seeing that in, I'd say, early 2024. There were folks that were like, I can't do that. I can't wait. And so there were contractors out there that would, say that, like private security companies would say, we'll go out to the property and, kind of intimidate the squatters. I heard in California, there was a guy who would move in with the squatters. He would squat on the squatters. Pretty dangerous, volatile stuff.
Yeah.
And who are these folks? I mean, that are doing this. Do they have jobs? Do they leave the property? And what do they do about, like, utilities? I'm pretty sure when the toilet's not flushing, they're not sticking around, a lot longer.
Well, Lester, I've seen some crazy utility things, because a lot of times, the owners of the property would cut off the utilities, or they weren't on in the first place, or something like that. And you would be astounded by what people do, whether it's running an extension cord from the exterior outlet of the neighboring property at night, living in the cold without heat, trying to tamper with water meters or even electrical meters. I've seen some crazy stuff where people are trying to make it work so that they've got, got utility, or just, they'll show a fake lease to the electrical department or, the water department and try to get an account set up, even though they're a squatter on the property. And I've seen a wide range of folks. get removed as squatters. Some were, probably on the brink of homelessness. You go into a house and they really didn't have furniture or much stuff. They're sleeping on a mattress on the floor, things like that. But I've seen others where they had enormous amounts of furniture and belongings and things of that nature. Some were, I've seen criminal activity. You go in and there's definitely, it's being used for people that are, into selling drugs or things of that nature. But it's a wide range. And I've seen many where there are children involved. I mean, it breaks your heart, but you go into one of these houses and there's clearly children there. I had one in northern Fulton County, and, of course, we show up with all the sheriffs and the moving crew, and all the neighbors come out because they know it's been a squatter for 6 months, and they want to tell you what's been going on and things. And so, the first thing I ask is, well, do you think they're in the property? Do you think they're there? And they said yes, because we know they're there because they took their child to the school bus stop this morning. And so, that was a situation where we went in, we removed the squatters from that property. It was a man and a woman, and their kid was in school. I think he was like 9 years old. And, that kid, they were going to have to go pick him up and say, we can't go back to that house. All your stuff is gone.
I was at a seminar, CLE seminar this past weekend where we had some real estate lawyers, similar practice to yours, talk about in the more rural areas where people are finding vacant land, maybe that somebody owns, that, don't have any property on it. They're not out there checking it every day. And they go and sell it, and, basically get the money, give a fake deed. And it sounds like that this is just sort of a more urban version of that kind of thing,
Well, listen, I've seen that sort of stuff, deed fraud. That's definitely a big problem that's out there. And, that's, I would say, is on the rise as well. I think in some ways, though, this is a little bit more just even basic, because, again, these people, they're not trying to make money off of it. They're not trying to, claim ownership or anything like that. I think they're just, trying to find a place to live for free for as long as they can. And they oftentimes, they know it's coming. I mean, a lot of times when I've gone in with the sheriffs, they know, like, okay, now's the time, and they leave most of their stuff, and that's it. And
they try to find another house.
I think, unfortunately, and I hope that this is changing at this point in time, but I think, unfortunately, there was a lot of serial squatting.
Yeah.
Are they not charged with burglary at some point, when, at the end of this?
Theft.
Well, Lester, that's an excellent point. And
fraud.
And Robin, you had brought up, like, what is the cause of all this?
Yeah.
I will say that I think one of the factors is there really has been no penalty. There's been no, efforts to prosecute a lot of these people, at least that I've seen. Every single squatter removal that I've ever been to, the sheriffs come in and they make the contact and they keep the peace while we're moving the stuff out and things like that. But at the end of the day, the squatters just drive off, and that's it.
Wow.
And so I think that's a big part of it, that there really was no deterrence. People knew you could do this and you weren't going to get arrested. You weren't going to go to jail. There was really going to be no consequence.
Well,
that's really amazing, to me that, I mean, it seems to me too, this would be the kind of case where you could go get a private warrant too. Here they are living in my house. I've just got this. We're going out to kick them out. We want the warrant so the sheriffs can take them into custody.
Well, and I think I agree with you.
Yeah.
A lot of times, what I've seen, though, because I've called the police, called law enforcement, anything to try to move things along. it's very, very easy for law enforcement to say, this is a civil matter and you've got to pursue it, through the regular process. It goes through the sheriff's office. That's really kind of been the operating procedure for most of the metro police departments that I've dealt with.
So you've got this rising crisis of squatters coming up in 2023 and backlog in the courts. You decide, hey, we need a new law. We need some better enforcement mechanism. And you helped in the passage of the Georgia Squatters Reform Act. Tell us a little bit about the new law. It's less than a year old, but I assume you're using it now. And so tell us what it changed and your thoughts about it, if it's working.
Well, so it did kind of two things primarily. One is it amended Georgia's criminal trespass code to create a specific offense for unlawful squatting. And that then gave law enforcement the authority to issue citations for unlawful squatting. And there's a procedure involved there where a citation is issued and the squatter then has 3 days to submit proper documentation, is what the law says, proper documentation to the law enforcement agency, a lease, something of that nature that shows that they have the right to be in the property. If they don't produce that documentation within 3 days, then they are subject to arrest for unlawful squatting. If they do produce that documentation, then a hearing is supposed to be set within 7 days, where the documentation will be evaluated in court. And if it's found to be invalid or false or something of that nature, then a writ of possession will issue, which will allow for that the squatters to be dispossessed from the property. And so that's the criminal side of things. Now, to be very frank with you, I have not seen that implemented in practice, with the exception of the city of South Fulton Police Department, who's been very aggressive on squatting in their jurisdiction. The Metro Atlanta police departments that I'm familiar with are not actively enforcing this, issuing these citations. Again, if they get contacted on a squatter issue, their procedure is to tell the person that they need to go through the civil process, and it would be handled through the sheriff's office. I don't know exactly why that is. It's been a little disappointing to me, frankly, that the police departments have not been a little more assertive on this. Typically, the fact pattern is that when the property manager or the homeowner or whoever it is discovers that there's a squatter in the property, the first thing they do is call the police. And that's what I tell people. First thing you should do is call the police. And so it would be my hope that at that point they could, evaluate, is this a situation where we can issue the citation? And I think that would really nip a lot of these problems in the bud, because people aren't going to mess around with, getting something like that from the police. But for whatever reason, that has not happened yet to my knowledge. So you have the criminal side of things that changed. And then the second area was they changed the procedure under the existing intruder affidavit law. And so there were some tweaks to the procedure, and it did a number of things. One is it expanded the universe of who could exhibit the intruder affidavit to the squatters. Before, I'd said that, it was just the sheriff that could do it. Under the new law, it expands it to basically anyone in law enforcement. The marshal's office can do it, regular police can do it. And so it makes it easier to find somebody to exhibit that affidavit. Now, again, in practice, usually my experience is it's almost always the sheriff's office that they get deferred to. The sheriff's office has the experience in it, so maybe that's why. So it expanded the universe of who could do that. And then it really created a two-step process with the affidavit. And so the first step is the sheriff or whoever it is exhibits the affidavit to the squatter, just like they were before. But then the second step is that you have to wait 3 days. The squatter has 3 days to file that counter affidavit. If you remember, I said earlier, under the old law, the squatter had to have a counter affidavit right then and there. And if they didn't, then the sheriff could, remove them right then and there. And so under the new law, the squatter has 3 days to come up with a counter affidavit. If the squatter produces a counter affidavit, then the matter is set down for a trial. The change there is that jurisdiction now is with the magistrate court, and it's not a jury trial, whereas before it was superior court and a jury trial. Now it's magistrate court, and so that's designed to kind of speed things along in the event that there is a trial necessary. If they do not produce a counter affidavit, then after 3 days, the sheriff can go back and remove them from the property. Okay. And so that's kind of been the biggest change, is changing the procedure with the sheriff's offices in how they handle the affidavits.
Does this speed things up for you? What's your experience? Do you think it's better with the new law? Is it working better?
Well, it is. And this is what happened. And I don't know if this was the intent necessarily, but, the biggest issue that I think everyone was facing in the spring of 2024 was this huge backlog with the sheriff's offices, because, it's very labor intensive, and it's very time consuming when you have a physical removal of a squatter, because you've got to have multiple sheriffs out there in order to be safe. And if the squatter has a lot of stuff, the homeowner has to hire a moving company to get everybody out. That can take hours and hours and hours. So potentially you could have a team from the sheriff's office be tied up all day on one property. And so when the Fulton County Sheriff's Office started getting hundreds and hundreds of squatters, that just takes a huge time period to work through. And so what the new law changed is it added that sort of initial step where the sheriff goes out and all they're doing is exhibiting the affidavit. There's not going to be a removal. You don't have to have a full crew there. There's not, the huge time possibility. And so what they were able to do is start displaying these affidavits during that initial contact much more efficiently. You could knock out many, many properties in one day. And the effect was that a lot of squatters were just moving out at that point in time. When the sheriff showed up with the paperwork, even though they didn't have the authority to remove the intruder at that point, it was enough of an impact that the squatter said, you know what, it's time to get out of here.
They got a
They saw the
three-day head start.
Yeah,
Exactly.
They saw the writing on the wall when a sheriff knocked on the door.
And in a lot of ways, that's a best case scenario for everybody, because if the squatter removes themselves on their own, because it's much less time consuming. There's much less risk of confrontation for the sheriff's office. It's less costly for the homeowner in terms of the moving company and things of that nature. And so that's really what's had the biggest positive effect, is that initial step where they display the affidavit. It's quicker, it's easier for the sheriff's office, and it's caused a lot of the squatters to just move out on their own. And so I think that has caused the backlog to lessen significantly and made things a bit more efficient. Now,
So if they get this affidavit, do they just wait for the sheriff to come back out? This counter affidavit, do they just wait for the sheriff to come back out, or do they have to go file that somewhere, or what's the?
Well, the procedure is a little bit different in every county, and that's been a little bit of the frustration for homeowners and lawyers and things like that. Every county's been a little bit different in how they handle it. Some counties will when you start the process, they'll make you file something in magistrate court. So there's a, civil action file number, and the squatters are directed to file their counter affidavit in magistrate court. In other counties, everything is handled through the sheriff's office. You never file anything in court. You just give the affidavit to the sheriff's office. And in that case, the squatter is usually told to bring the counter affidavit to the sheriff's office. And so I guess the flip side of having that first step and the efficiency that comes from it is, I do think that there had been more counter affidavits filed and more trials scheduled because the squatters are being given more time to file that counter affidavit. And so while the majority of them may move out when the sheriffs knock on the door, there is a percentage that will say, you know what, I want to get a little bit more time. And so they'll file that counter affidavit and ask for a trial. And so a trial gets scheduled in magistrate court, and there's an even smaller percentage who are actually showing up. Most of them just, the court date gets scheduled and it gives them a little bit more time, and then they just don't go to court. But I have not personally been involved in a trial like that, but I do know there have been a few where they've actually gone into court and tried to say, I'm a real tenant.
Oh gosh, I was just wondering, what did they put in the affidavit? I have no claim to this property, but I'm living here. I mean, what in the world?
Well, typically the most common fact pattern is the squatter will produce a fake lease, and it'll become pretty obvious pretty quickly that this lease is not with the person who actually owns the property. And so the explanation that the squatter will give is that, well, I don't know who is pretending to be the landlord here, but I answered an ad on Facebook Marketplace, and I've been paying my rent and all this other kind of stuff. And, to be fair, that is a scam that happens. There are people who pose as owners of properties and lease them out illegally and pocket the money and disappear. And so that is, a real thing, and it's a real issue that's out there. But in the vast majority of the squatter cases I've been involved in, the people have said that that's the case, but that actually has not been the case. So I don't know if they continue that story when they go into court, say like, I'm, been victimized here, I paid all this money, and, I thought this was legitimate, that sort of thing. I don't know exactly what they're saying to the judge, but it's a tricky place to be and try to make that kind of defense, which is why most of the squatters don't go that far.
Mm-hmm. And David, most of your clients, or maybe all of them, are the homeowner, right?
That is correct.
All right. And so your experience in the last year, do you feel like this law is improving things for your clients?
I would say so. Again, to me, it's the efficiency, it's working through the backlog. And so, DeKalb County, early 2024, we were seeing 7-8 months for, the process to go through. And, now it's maybe 2 months, maybe 3 months, which is, still longer than our clients would like, but it's more acceptable. It's more efficient. It's much better than it was. And so, I think part of that does, the credit needs to go to the sheriff's offices and the magistrate courts, because they are working very hard to implement this and be more efficient. And so I know it's been a lot of work, and I want to credit them for that. But I think, part of it is also that one process that was put in the new law where, you're going to go out, you're going to exhibit that affidavit. It's going to be quick. It's going to be easy. And that's been enough to push a lot of the squatters to just remove themselves from the property.
Great. Looking to the future, do you think the new bill needs to be revised, tweaked, anything added to it, or do you see any challenges in the future with this bill? Or are you happy with it?
You know,
and I shouldn't say bill; it's actually a statute now. So are you?
Now.
Yeah. Are you happy with how it's working, and or do you think there are some challenges ahead, or something that needs to be changed?
Well, I'm not sure what the future holds. I mean, my hope is that we will go back to the pre-COVID state of things where you just don't see a lot of squatting.
Yeah.
My hope is that with the magistrate courts running more efficiently in terms of their landlord-tenant matters, and with the law being, implementing, being faster, with the sheriff's office, my hope is that the squatting issue will go back to where it was, not very prevalent at all. Mm-hmm. And if that's the case, then the law as it exists is probably going to be fine. I could foresee that there may at some point be some legal challenges. If someone takes it into court and then does some appeals, there could be some challenges to aspects of the law. I think there are some areas that, there are clarifications needed. For example, in the criminal side of things, it says that a hearing has to be held within 7 days. The statute doesn't say who holds that hearing, what court has jurisdiction, exactly how that happens. I think that there's a question as to what constitutes exhibiting the affidavit under the law. The law says that, the sheriff or whoever it is has to go out and exhibit the affidavit. Well, does that mean that you have to physically show it to the squatter? Can you just leave it on their door? There is some difference of opinion between the counties as to what's the proper procedure there. And so, that may get worked out. It may be litigated. Who knows? If it is litigated, then the law may have to be tweaked.
Talking about the criminal aspect, it really still doesn't make it a crime, though, right? I mean, I'm thinking there should be a crime for squatting that is theft or fraud, or
well, it's really funny because I've
something
had
like that.
I have clients that have knocked the door down at their girlfriend's house, and they get charged with burglary, for entering a dwelling, unauthorized. And it seems like, to borrow from the language of trespass, this is a continuing burglary, So it just sort of amazes me that that law enforcement, goes out there and tells the burglar they got to leave, but you don't have to get in the back of the patrol car here.
I agree.
Absolutely. I agree. And, if you go back and you look at some of the press around this law when it was passed last year, there was a lot of, squatting is finally a crime, or we're criminalizing squatting, that sort of thing. And my response was always, it's always been a crime. I mean, whether it's breaking and entering, burglary, fraud, theft,
yes,
criminal trespass. I mean, there's any number of counts that you could consider for what the folks were doing. I think this just kind of formalizes it and puts a label on it. I mean, it does say that in the statute, it puts a name on it as unlawful squatting. And it does clarify that that is...
As if there's lawful squatting.
Very good point. It does, clarify that it's a misdemeanor and, has some guidance on that sort of thing. But, I was astonished. That property I talked about where the child was at the school bus, that was $1 million house in North Fulton, the far end of Roswell. Beautiful home, finished basement, hot tub. I mean, just a great area. And it probably rented for $5,000 or $6,000 a month. And those squatters had been in there for a year.
Wow.
And so, you're talking about $60,000, $70,000 in lost rent.
Mm-hmm.
I mean, if you went out and stole $60,000 or $70,000 from somebody, you're talking about serious criminal infractions, and they just were never interpreted that way.
That's very interesting. I had no idea. Yeah, that would definitely be a felony anywhere else, but they're treating it differently. Well, David, thank you for this illumination into the Georgia Squatters Reform Act. I had no idea, other than what I see on TV with another incident of a squatter. I'm like, how in the heck does that happen? It just is mind-boggling to me. But thank you, and I'm sure many homeowners, they know to call you now if they have a squatter. David's the person to call. Come, he'll help remove the squatters. So thank you for illuminating that for us. We ask our guest, David, one question at the end, and we ask our guests the same question. And you have a very unique area of the law that I don't think we've ever talked to somebody in real estate. But our question is, how do you define justice? Or what does justice mean to you?
Well, thank you, Robin and Lester, for having me here. I appreciate it very much. And I will answer that question, what is justice? I think from the perspective of my particular area as a civil litigator and as a litigator that specializes in real estate law. And so from that perspective, I'll say that it's about using the law to solve problems with fairness. And what I mean by that is when my clients come to me, they're coming with a problem. And it's something that they've been dealing with, living with, and they're not able to solve it on their own. And so they come to me, and my hope is that I can use the law and my knowledge of the law and my skills to help solve that problem for them, whether it's a squatter on the property or a title issue or a boundary dispute, whatever it is, help solve that problem and solve it in a fair way. And if I can do that, then I've been a part of justice.
Great answer.
Great answer. Absolutely. Well, it's just been a delight having you with us today, David. And just to remind our listeners, we've been talking to David Metzger. He's with the firm Williams Tusink in Decatur, Georgia. And David, what's your website? WilliamsTusink.com.
That's correct.
Yeah. So you can find more about David and his law firm at Williams Tusink, which is TEUSINK.com. And lots of information. I looked at your website, lots of information on that as well. And I know you write some blogs, and homeowner can go to that website and find out a lot about real estate and how to give you a call.
Yep.
Very good. Thank you, folks. I appreciate it.
Thank you.
Thanks for being on. All right. Now we have come to the portion of our program where Rob and I try to share some legal news that, it's current when we talk about it here, usually. And Robin, I'll let you go first. What legal items in the news have you seen that might be of interest to our listeners?
One item in the news that's law related is the use of AI. And it's just becoming rampant. But what caught my eye is that there have been at least two separate incidents where a judge has sanctioned attorneys for using AI to write their briefs, and where AI created total fiction, made up cases. They call it hallucination, AI hallucination, which is a bunch of BS, in my opinion. But these lawyers filed a document, a pleading with a court, one of them federal court, and represented to the court that they had done their work and these sites were correct, and it was a lie. It was a total lie. And the first one came from a law firm that touts itself as America's largest law firm. And the attorney was Mike Morgan. And he had to file an affidavit. His affidavit's all over in the news right now. But he had to file an affidavit in federal court, the District Court of Wyoming, saying that yes, they used AI. He tried to blame it on his associate, but admitted he had not read the cases. They were made up cases. They didn't exist. He apologized to the court, but he had to put an affidavit in the court. Court sanctioned each lawyer. The court first sanctioned the main lawyer, the associate, I think $3,000. He sanctioned Mike Morgan for $1,000 and the local counsel for $1,000. And it's a scathing order on sanctions. Probably ought to put this on our website, but scathing order on sanctions and other disciplinary action from the district court judge, Judge Kelly Rankin in Wyoming. And the other disciplinary action is referral to their state bar. So not only monetary sanctions, but referral to state bar.
I was on a panel this past weekend. I went on the tropical CLE that you've been on, I think, before as well, and was on a panel with two of our Court of Appeals judges talking about AI. And one of the things I think we sort of agreed on is that, it's an honesty issue, not an AI issue, And so if it doesn't really matter that AI made up this very good looking brief. That would be the same thing as having a person write that brief, but when you sign it and it's got the fraudulent fake authority in it, that's the real crime. And so there was discussion, and one of the questions that was asked, and this Judge Ben Land, Judge Todd Markle were on this panel with me. And one of the questions was, do we need to certify we haven't used AI? And I think we all agreed that that's sort of a useless thing. I mean, it'd be like, I used Westlaw, or I didn't use Westlaw. It's how you use that technology. And but I think it's getting a bad name, AI is, because of misuses like that.
Misuse. And Judge Rankin, in her lengthy order of sanctions, says this: the key takeaway for attorneys is simple. Make a reasonable inquiry into the law before signing or giving another person permission to sign a document as required by Rule 11. If an attorney does not do so, then they should not sign the document. However, if the attorney decides to risk not making reasonable inquiry into the existing law, then they may be subject to sanctions. And as you say, that's been the standard forever. Mm-hmm. Make sure before you sign something that you can verify that you've looked at it, it's accurate, it's truthful. It's just mind-boggling to me, Lester, that an attorney would present something that has made up cases.
Right.
I mean, when I sign a pleading, I'm telling that judge in that court, trust me, I looked at every one of these, and you can vouch everything I say in this pleading is accurate.
Right. It's amazing.
You just lose your reputation if you don't do that. And so anyway, and there was another one in Texas, just yesterday, Texas attorney dinged for AI generated fake citations. And that lawyer was fined $15,000.
Wow.
For doing the exact same thing. So,
well, my news item today, I think in some ways it's similar, not that it involves AI, but that it involves the sort of integrity of the courts. And it's an article from the New York Times dated yesterday, which would be February the 25th of 2025. And it's Supreme Court, that's the United States Supreme Court, grants new trial to death row inmate in Oklahoma. Both sides had told the justices that long suppressed evidence had undermined the case against the inmate. And so the Oklahoma Attorney General's office, there's this guy on death row. His name is Richard Glossip, Glossip, was convicted of murder, sentenced to death by execution. And the Oklahoma Attorney General's office said that certain exculpatory materials had been withheld. They asked that the sentence be vacated, also with Glossip's attorneys. and it went to the Oklahoma Court of Criminal Appeals, and they denied the joint motion to grant this guy on death row, where the state who's put him there is saying, we didn't play fair at the trial.
We messed up. Yeah.
It went to the United States Supreme Court from there. The United States Supreme Court even appointed somebody to argue to try to uphold the jury verdict, which that seems like a little much when they're confessing that, when we have an adversarial system, when both sides agree on something,
Right.
And so the decision came out, and it was there were 5 justices. It was a 5-3 split decision.
Right. It wasn't. It was.
And I'm going like, okay, so at least 5 people on the U.S. Supreme Court think if the state comes and tells you they cheated and they're going to kill this guy after having cheated to get the verdict, we'll do something about that. But the others are like, well, there are a lot of procedural bars and whatnot. And I just think it's horrible for the justice system to play games with somebody's life like this. Whether you're for the death penalty or against the death penalty,
right.
Whether you like the justices in the majority or against the majority, when you have people that are relying on bad facts, just like in your AI item, they're relying on wholly made up law. It's just a pretty poor look for the justice system.
Oh man, I totally agree, and I saw that yesterday. And when I saw it was not a unanimous opinion, I'm just shaking my head. I cannot believe you've got the prosecutor, as you say, admitting they didn't play by the rules, and yet two or three justices were willing to kill a man when he didn't get a fair trial. That's beyond belief in our system. It's really a sad day for our justice system. But I saw the same thing, and I just couldn't believe it. That man, Mr. Glossip, I read the article, said he ate his last meal 3 times.
And one time was within 15 minutes of being executed.
I can't even.
It's incredible.
It is incredible, but I think I agree with you. It's just a really sad day for our justice system, and I think an indictment on it. There is a sense that in these cases, we want finality. Okay, I understand, but we don't want finality to put an innocent man to death.
Well, how is that?
That's crazy.
Assume you're the biggest death penalty advocate, in the United States. That's your political belief.
Yeah.
You still want guilty people punished, not innocent people, and you want people punished after they've had a fair trial.
Absolutely. I just really no words for the dissenters in that opinion.
Yeah.
And we know who they are, the usual suspects.
Yes, they are. And one, I think, was Justice Barrett, who was for overturning the death sentence, but didn't want to grant it. He wanted to remand it for further proceedings. Yeah. I can accept that.
Okay.
So anyway, you've been listening to See You in Court, episode number 46. And we want to thank our sponsor, the Georgia Civil Justice Foundation. We also want to thank our producer, Philip Hoover, and all our listeners. You can learn more about me if you're really that curious. I'm lestertate, and my law firm website is aiken-tate.com, and more about robinfrazerclark at georgiatriallawyers.net, gatriallawyers.net, gatriallawyers.net. And you may listen to all our episodes. In fact, we hope you will listen to all our episodes, this podcast, by going to seeyouincourtpodcast.org. We hope you subscribe to the podcast and share it with your friends and family. You can find See You in Court on iTunes, Spotify, Stitcher, and anywhere you get your podcast. If you want to send us questions or make suggestions about an interesting legal topic, we would welcome that. And you can email us at seeyouincourtpodcast@gmail.com. And that wraps up our episode for today, Robin. Until next time, we'll see you in
court.
You've been listening to the See You in Court podcast, brought to you by the Georgia Civil Justice Foundation. Remember, justice is a shared journey, and your engagement makes all the difference. For further insight and resources, visit our website at www.seeyouincourtpodcast.org. Subscribe to our YouTube channel at See You in Court Podcast for additional content. And don't forget to engage with our community on Facebook.com/seeyouincourtpodcast. Special thanks to our producer, Philip Hoover. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at www.fairplay.org. Until next time, we'll see you in court.